Now, the lawsuit between Drake and UMG has finally been dismissed, but what if I said this lawsuit might not be the only one that Drake is involved in? There's been another case cooking in the back that Drake might be tied to, and it goes back to the cover art of Meet the Grams. You see, when this beef kicked off, Meet the Grams had cover art, and this cover art and the items in it have something to do with Drake and this separate lawsuit. As stated in other videos on this channel, the items were obtained by a security guard that worked at the Mark Hotel, this hotel Drake had stayed at. He can be seen in multiple videos online around the same time this separate lawsuit takes place. The security guard, who goes by Ebony Prince, has been dropping so many vague clues and hints about Drake's activity at this hotel, and this lawsuit might expose what Ebony Prince was suggesting all along, at least to some degree. In a recent post made by Ebony Prince on Twitter, he refers to a lawsuit after Drake's defamation case was dismissed. He made a post saying, "Young Theodore's next. Am I lying? LMBAO." This post seems to give off the impression that Drake's problems haven't fully gone away, and it might end up taking a stranger turn than he thought. You see, young Theodore that Ebony Prince is referring to is Theodore Weintraub. He was a guest at the hotel at one point who would drink there despite not being of age. Once Weintraub got kicked out, once Theodore got kicked out for being a nuisance, he took it personal and started to protest against the hotel. He would protest in front of the hotel with a group of people with signs chanting things at the hotel, saying that the Mark has rats, the Mark loves Epstein. He was saying all of these things after getting kicked out. During this time, Drake was staying at the hotel as well. He was staying there as a VIP guest. There's even videos on YouTube of Weintraub protesting in the background, and you could hear him protest as Drake is coming in and out of the hotel. This right here puts Drake, Weintraub, and Ebony Prince all in the same place at the same time. And like I said, this other lawsuit Weintraub filed against the Mark is dragging Drake right into it. See, for a while, Ebony Prince, the security guard, had suggested multiple clues. He had dropped multiple hints that Drake was up to no good at this hotel. There might be stranger things that Drake could have been involved in at this hotel. We'll keep it alleged. But these strange things that Drake could be involved in are underlying with the messages from Meet the Grams, things like that of that nature. And even though he hasn't stated directly what Drake was up to, this lawsuit between the Mark and Weintraub could expose some of that stuff he was referring to. So I'm going to read this transcript from this lawsuit and point out the key points in this argument and why I feel like the Mark Hotel is trying to protect Drake and maybe hide other secrets. There's a transcript between the judge and Weintraub's lawyer. His name is Mr. S's. And this conversation is important because this is basically the hotel protecting Drake from this situation, from this lawsuit, and preventing him from being named. He says, "Thank you, Your Honor. The underlying motion in which the court decided on NYSCEF 81 was the motion to compel by my client to the plaintiff to respond to discovery. A lot of the discovery plaintiff would not respond to without a confidentiality agreement. I objected to the confidentiality agreement because the plaintiff, I argue, wanted a broad subsuming confidentiality agreement, not only to VIP guest number 1 and VIP guest number 2, who are enumerated and highlighted in the complaint, but also to a lot of other information requested in the discovery that my client propounded." Now, Mr. S's, Weintraub's lawyer, is talking about VIP guest number 1 and VIP guest number 2. This, in theory, is Drake and his dad. Those were VIP guests around the time that Weintraub started cooking up this lawsuit. So the judge and the lawyer go off record to find the document that they're talking about. They come back and they find it. They get back on record, and the judge says, "Yes, counselor, you can direct me to the terms of the proposed stipulation." Mr. S's, Weintraub's lawyer, says, "Yes, Your Honor. So it's NYSCEF document 88. As Your Honor pointed out, it's page 2, section 3, as used herein," and then in quotes, "confidential information under section A." And it goes on to say, and I'm snip sizing here, "trade secrets, proprietary business information, competitively sensitive information, and other information disclosed of which would be in good faith of the judgment of the party, or as appropriate non-party designating the materials confidential, be detrimental to the conduct of the parties or non-parties business." And it goes on. And then it adds highly confidential, but we can deal with that also. But the confidential information, that could be pretty much anything relating to the plaintiff's business. It's not specific to VIP guest 1 and VIP guest 2. I don't know where, and I'm not going to guess where plaintiff might put VIP guests 1 and 2. They might put them in confidential or highly confidential to address specifically the issue of VIP guests number 1 and 2 again. As I highlighted before, they are highlighted in the complaint. It is a substantial basis in the complaint. It's buying my client a lawsuit. And the problem here, and I just want to stop right here to explain, Weintraub's lawyer is referring to language in legal documents, which defines what counts as confidential information. The definition includes things like trade secrets, proprietary business info, competitively sensitive information, and other info that a party or a non-party believes in good faith would harm their business if it became public. He's saying this defamation is very broad. It could include almost anything related to the plaintiff's business, not just limited things like names of VIP guest one or VIP guest two. Mr. S's, the lawyer, is arguing the definition of confidential information under the protective order is not limited to specific names or individuals. It's general and expansive. It covers any info that could hurt the business if made public. Therefore, more of the material should qualify as confidential, not just the narrow items like identities or certain VIPs. So in this case, the hotel is trying to protect the identity of VIP guest one and VIP guest two. The mark calling their information confidential under the protective order, the party wants to prevent that information from becoming public, but they're also trying to protect much more than just VIPs. The lawyer is emphasizing that the confidentiality agreement isn't just about VIP identities. It's written broadly enough to cover all kinds of sensitive business information, not just names, but trade secrets, internal process and strategies, and client info. His point that he's trying to make is that confidentiality protections should apply to a wide range of business related materials, not just specific people like VIP guests. But the hotel is protecting these VIP guests. I wonder why. Now, this is what the judge says. Just a minute, because I have a question now. I want to look up at Judge Healy's order and what did she actually get wrong? What did she say in her order that you say she got wrong? Let me look at that order. Just a minute. So looking at the cross motion section of her decision, she speaks about, quote, standard confidential agreement to allow the personal identifying information of the third parties to remain confidential. That's what she says. And then she says, ultimately, quote, however, the court also finds that based on the record, defendants' alleged behavior, including harassing and intimidating the plaintiff's hotel patron, there is a need for confidential order to be issued to protect the identities of the non-party witnesses. So that's what she said. What did she get wrong there? I believe, Your Honor, that the identity of the non-party witnesses might be okay for a protective order, but VIP guest one and VIP guest two, and I argument this in my papers, is that when I subpoenaed these guests and the information potentially gets out that they have been subpoenaed, in this case, plaintiff is going to come running to the court potentially and argue that my client, Mr. Weintraub, released that information to the public. When the second I serve that subpoena, who knows on the VIP guest one and two side who's going to learn of this information and leak it to God knows who. And then my client is now going to have to defend himself. The judge says, your intention was to subpoena these witnesses. Obviously, you need to know their names and their addresses. Weintraub's lawyer says, correct. The judge says, but the question is, should that be published? And I think that the intention, and I understand based on what I'm reading, is that you would not publish that, you would serve it. Now, if somebody chooses to publish that, as long as you haven't done it, I'm not sure how otherwise this would work. I mean, again, you would not be allowed to publish. It would be sealed. Honestly, it would be sealed. That's how these confidentiality agreements work, and it would not be a matter of public record. So I'm not sure what you believe Judge Haley got incorrect in this regard. Again, Your Honor, of course, I'm not going to reveal that information to anybody. And of course, I'm going to make sure my client doesn't. But the second I serve the subpoena, I don't know who on VIP, he gets cut off. The judge says, that doesn't matter. Right. You're going to serve the subpoena, not on the press. Hopefully, you're going to serve the subpoena on the individuals. What they choose to do with it, or anybody else that somehow gets a hold of the subpoena served on somebody else, that would not be a breach of confidential agreement by you. If somebody else decides to publish it, as long as it's not you, how have you violated the confidentiality order? I mean that I'm not persuaded because we have confidentiality orders all the time. And the idea, the court is sealing that record, so it's not for public consumption. If somebody else manages to get a hold of the confidentiality information unrelated to you or your clients, how is that a violation of the record? I don't understand. I mean, the violation of agreement, I don't understand that argument. I won't interrupt you, but I want to know in general, how does someone else unrelated to the parties who somehow gets a hold of confidential information and publishes it, how does that, unless you facilitated that? How is that? Certainly by serving a subpoena, you haven't facilitated that. And I would think that you would put something on there, perhaps saying it's confidential. It should not be shared, but nonetheless, if the witness decides to publish it, how have you violated the confidential agreement? The lawyer says, thank you, Your Honor. My issue is not, of course, I'm not going to reveal the information to anybody, but my concern is when I serve the subpoena and someone on the side of the party that receives the subpoena, they have the right to do whatever they want with the information. And if they publish it for whatever reason, it's potentially that the plaintiff is now going to come and argue that I or my client revealed that information in breach of confidentiality agreement. And now I have to go and prove that we didn't. In other words, it's buying a lawsuit within a lawsuit. So now I'm going to have to prove a negative that I didn't do something. And it's not like a piece of paper that Mr. Klein is giving me. Mr. Klein is the Mark Hotels lawyer that I can keep in any office, not revealed to anybody. And no, it's not going out anywhere. This is information that's going to a third party that I can't control. And again, I don't know what they'll do with it, but if they do publish it, Mr. Klein could say you or your client published this information. I'm going to say no. The party who I serve published this information. And now we are going to be before you, Your Honor, arguing did I or my client breach or did not. And now we have to prove that someone else revealed this information. Like I said, it's a lawsuit within a lawsuit. So Judge Healy should have denied the order protecting the information, correct? Yes, because the plaintiff made this forefront of their allegations against my client, that my client did this in front of VIP guests, and therefore they have been damaged as a result. Now, like I said, VIP guests 1 and 2 are Drake. And what's interesting is that the judge starts to see it this lawyer's way and starts to understand, I don't get why they're trying to put all of these confidentialities on everything and being vague about it. Document number 88, which is proposed confidentiality agreement. Again, confidential information is not just VIP guest number 1 and 2. It is a whole broad set of information, including documents which are not part of this order, as Your Honor pointed out. It's with regard to the identity of the non-party witnesses. The court, thank you. Let's hear from the counsel Klein. Please, counsel Klein Estes, mute yourself. So Mr. Klein is the Mark Hotels lawyer. He basically makes this argument after what Mr. Estes says, but to sum it all up, he says, so Your Honor, to wrap up, particularly, this is not an appropriate basis for a motion to re-argument, and substantively, Mr. Weintraub is no more correct than he was on the first time around with respect to the court's authority to regulate pretrial discovery. So for either of those reasons, Your Honor, we respectfully request that the motion be denied. The judge responds, so my question to you, Counselor Klein, is other than the personal identifying information of the call it VIP guest 1 and 2, what else was being sought? What else in your cross motion did you seek to protect? What information? That's why I'm a little confused, because we're talking about now trade secrets, etc. And it seems to me that was not implicated in the cross motion. The Mark Hotels lawyer, Mr. Klein, says, so Your Honor, the demands that were made in this case were extremely broad, requesting, for instance, the identities and contact information, not just of the principal guest victims, but of all witnesses, which just give you more context. Mr. Weintraub was out in front of the Mark Hotel. He gets cut off. The judge says, what trade secrets were being sought? Because I see that language in the proposed stipulation. It does seem extremely broad, and I'm wondering what was before Judge Headley. Mr. Klein says, Your Honor, first of all, the trade secrets, that order was not in front of Justice Headley. No, I'm asking you. Judge Headley said motion granted. The parties should negotiate a confidentiality order, and the names and I guess the personal identifying information of the VIP guests would be protected. Mr. Klein says, well, that's not all she said. The court says, well, I'm asking, tell me in the order, what else did she say about that? I don't see anything else actually in the order about trade secrets, for example. Mr. Klein says that's another problem with this motion, which is all that the court ordered. I'm asking you, he's re-arguing, and you're saying, Judge, deny the re-argument. But one of the arguments he's making is, I think, well, the Judge Healy granted on overbroad protective order, and I'm not seeing that actually in her order. I think perhaps your argument is the stipulation that was drafted doesn't comport with what she ordered. Mr. Klein says, right, but that's not the motion. The motion is not a motion too. We haven't gotten to that point. In accordance with the court's order, which was not asking for a specific set of terms in the confidentiality order, it just said to agree on one. We submitted one too. Mr. S has refused to engage completely. The court responds, what were you asking to be protected when you argued before Judge Headley? That's what I'm trying to figure out. Right, and there's a series of things. The judge says, what were you arguing other than the VIP guest identities? Mr. Klein says, it's the names of any third parties or their contact information who might be implicated by the discovery demands. There's also information about the insides of hotel, including locations of security cameras and security personnel who would have information relevant to the allegations that wouldn't be appropriate to public consumption. She says, what was in your cross motion? The cross motion simply sought a protective order so we could designate with respect to what? Not just respect to these two people. Tell me, I don't know. I'm telling you, Your Honor, it's with respect to anything that we would deem to be appropriate under the terms of the confidentiality order, and this court regularly uses. And in the event of a dispute, like if we labeled something confidential that Mr. S has disagreed with or his client disagreed with, the proposed order allows for those disputes to be handled in good faith and in many cases without the need of judicial intervention. So I understand that. Just give me a moment. Honestly, I don't see anything else other than that in your memo in terms of what you're trying to protect, the identity of patrons. So I'm a little confused. What else? It's very generic what you're saying. So we're going to do a general confidential agreement, judge, covering everything regardless of what the defendant seeks. I think it's appropriate to take a step back and really think this through. What I'm saying is we should use the standard confidentiality order that this court uses. And at a minimum, we should abide by the court's order that required the parties to discuss the terms of the confidentiality order. By saying that the court got it wrong, what Mr. S is saying is that we shouldn't even have to have that discussion. Now, let me just stop it right here because I want to explain to you something. This back and forth that the Mark Hotel's lawyer, Mr. Klein, is having with the judge is basically off of the protection of the VIP guests 1 and 2. They said, aside from VIP guest identities, what exactly are you looking to keep confidential? This is what the judge is asking. Mr. Klein says the names and contact info of the third parties who might come up in the case, whether it's employees such as Ebony Prince or other guests like Drake. Internal information about the hotel, like locations of security cameras, which Ebony Prince had talked about and showed in the past, identities or locations of security personnel, which could be Ebony Prince's real identity, or any other security related details. He argues that this kind of info shouldn't be made public because it could compromise privacy, expose people unnecessarily, and raise security concerns. But why do they want to protect their name so bad? The court points out that the cross motion that Mr. Klein's formal request may not clearly state all this. Mr. Klein is trying to push back slightly by saying that the cross motion does seek a protective order. They want to designate any sensitive material as confidential under standard terms the court usually uses. If the other side disagrees, in example, Mr. S thinks something shouldn't be confidential, the protective order includes a built-in dispute resolution process, usually handled without going back to court. But the real issue here is that the protective orders are common in litigation, especially involving business or individuals where privacy or trade secrets are at stake. But this is the problem. If the protective order is too narrow, it risks exposing sensitive information. If the protective order is broad, it could unfairly limit public access or slow down discovery if overused. And I think that's what they're doing in this case. The judge appears to be skeptical or unclear of exactly what Mr. Klein is asking to protect. Mr. Klein is trying to cast a wide net. He wants the ability to label a broad range of info as confidential. The judge wants more clarity or specifics, perhaps to prevent an overreach. So the judge wants to know exactly what they're trying to protect. But let's just be real. They're just trying to protect Drake. But if you remember what we talked about on this channel and the name that Drake had went by at this hotel, his name at this hotel is Richard Fitzenwell. And you could see that he's a VIP, and it clearly states that this is an alias that he goes by at the Mark Hotel. Ebony Prince, the person who worked at this hotel as a security guard, had stated, why don't we call him by the name he prefers from now on? Mr. Richard, aka Dick Fitzenwell. What type of perv wants service staff to address them as such? Just despicable. Is everything about X with this guy? Now, I feel like the reason why they are trying so hard to protect Drake's name is because they don't want these weird things going out into the public. They don't want people to know that they were calling Drake Dick Fitzenwell at the Mark Hotel, where Ebony Prince is accusing him of all these crazy things. There's a lot of things that Ebony Prince was saying. There's a lot of strange things that Drake was doing. There's all of these incident reports that he says are tied to Drake. There's multiple counts of different things involving ex-workers. He said 3 months ago, I simply asked for the truth to be what came out. All that was given was more lies. I have yet to tell a lie. There was also this conversation about wine coolers from 616 in LA. There was also pictures of Drake online with Snow. We all know what Snow was accused of. We don't need to go that far, but this is what Ebony Prince has said. So am I the only one that ponders on the legality of suggestive communications through electronics with minors in New York State? And there's recordings of it. He wasn't wrong. There was recordings of it. They were on stream while she was doing that weird activity. It just so happens that Drake was doing this while he was staying at the Mark Hotel. There's a lot of weird things at this hotel that Drake was caught doing, that Drake was doing at this time. I can't completely say what Ebony Prince knows, but I could say that he has been trying to tell people that Drake has been doing some weird activity at this hotel. From the name he likes to go by, from the things that he was doing in his room, from talking to people online, to doing all of these weird activities that could involve guests that he was sneaking in through the back door, sneaking in through the front door. I don't know. We'll keep it alleged. But I feel like this is why the Mark doesn't want to give that information out to people. I feel like this court case, if they do decide to reveal that Drake is a VIP guest and was going by Richard Fitzenwell, aka Dick Fitzenwell, and all of these other crazy things were starting to happen, this case could open up a can of worms for Drake in the long run. I think this case right here could introduce us to a rabbit hole that me and you've known about this channel for a long time. There's no doubt in my mind that if Drake gets named in this lawsuit and then people find out that he was being called Dick Fitzenwell at the Smart Hotel, it's without a doubt that this will go more viral than the lawsuit, because then people would start getting into all the weird activities that he was involved in at this hotel at this time. We'll keep it alleged, but I feel like this is the main reason why they don't want to give the name. This is why the judge is confused as to why they don't want to give specifics and why they're so dead set on trying to protect the guest in a broad way, in an overly broad way. How come you don't want to just say exactly what you want to protect? How come you want to just keep it so vast? It doesn't make any sense unless you're just trying to protect Drake and other people that you had at the hotel that have weird activity going on that you don't want to expose. I'm not sure. We'll keep it alleged, but y'all tell me how you feel about this. I think it's real interesting how the lawyer is trying to argue this confidentiality agreement and the judge is confused why they don't want to get into the specifics and they're just trying to keep it broad. It is strange to me. If Drake gets named in this hotel, if they give them access, I wouldn't doubt that this will go viral. Without a doubt. Drake just finishing the lawsuit with UMG and then he gets named in this weird one. I don't know, bro. But y'all tell me how you feel about this and get back to me, man. Y'all tell me how you feel about this whole scenario. I'll get some more updates in a later video, but y'all tell me how you feel. Like, comment, subscribe, and I'll see you on the next video, man. Peace. Keep it alleged.